the Supreme Court here give a really nice summary of what the law is.
Your own defense is really what precluded the opportunity for you to have lesser includeds.
You're not just talking about who done it or did this person commit this offense. It's what punishment ought they to receive.
It strikes me as what must be going through these people's minds and hearts when this happens.
Tough situation. And of course, this case, when it happened, grabbed some headlines. Okay, well, welcome back. Here we are again, filming another episode. How you doing today?
Good. It's good to be back.
It's always good to be back. Have you been busy?
Yeah.
Going to court?
Not as much as you. You've been in court more than me.
Very busy in court. I've got a number of cases that I'm dealing with that I'm trying to either resolve or go to trial. Looks like I'm going to be going to trial a few times in the next couple of months.
So that sounds fun.
Well, it's what we do, right? As defense lawyers, that's what we do sometimes.
That's what they say, right? Criminal defense, if you want to be a lawyer who goes to court, criminal defense or family law, right? Those are the two that actually argue cases and go to trial. So, that's what drew me to it. So,
you know what? On the topic, one question that sometimes we get, that I get, maybe you get this too, is sometimes clients are astonished. Like, how come the prosecutor isn't just dismissing this case? The case seems absurd. Why are they not just dismissing this case?
Yeah, sometimes I get that. Yeah.
I mean, prosecutors, they bring cases against people, and we presume that they're serious about it, and so they move forward. And so sometimes we go to trial.
Yeah.
Speaking of going to trial, we're going to talk about a woman who went to trial. Her name is Wendi Andriano. This is a case from Arizona from 2000. A female defendant. We just finished, the last two episodes were about Winnie Ruth Judd, another female who was prosecuted for murder. Wendi, tell us about her. What was her charge?
Yeah, so staying with our theme, we're talking about Arizona cases, big Arizona cases. It's a unique one, and we'll talk about some reasons why Wendi has become kind of a unique case in Arizona. But she was charged with one count of first-degree murder. Sometimes people think that just because somebody's charged with first-degree murder, it's automatically a capital case, meaning that it's a death penalty case. That's not true. In fact, it even says in some of the decisions that we read that that's not how it should be, and that's not how it's meant to be, that those death penalty cases, not all states have the death penalty. Arizona is one that does, and it should only be used and sought in certain cases. And so we'll talk a little bit about that.
Right, and the cases that do merit the death penalty, number one, it has to be decided now by a jury. That law changed a number of years ago where the jury makes the decision about death.
Right, meaning they always make the determination on guilt or innocence.
That's right.
But it used to be that the judge would decide death or life in prison or whatever the sentence is. Now that second part has to be done by a jury.
That's correct. That's based on a number of U.S. Supreme Court decisions, really in the early 2000s, that kind of solidified that. Previously, you would go to trial, the jury would determine whether a person was guilty, and if they were found guilty, well, then the judge would decide, is there enough to warrant the death penalty? Now that has shifted, and the jury now has to make the decision, do we impose the death penalty? Now, in any non-capital case, meaning a case that's not a death penalty case, the judge still decides sentencing. So in nearly all of criminal cases, judges decide what the sentence is going to be based on the law. But in capital cases, juries have been now charged with making that decision. Tough decision to make for a jury.
Really tough. And it's really an interesting thing on why they've done that. That is, it's a lot to put on a juror, just an everyday person who goes in, and when they're doing what we call voir dire, the beginning of selection of jury, one of the questions they get asked is, this is a death penalty case. You're going to be asked to make that decision. If you're told the law, are you able to follow that and impose death if that's the appropriate sentence? And if people say they can't do that, there's a lot of people who just don't believe in the death penalty,
right,
that it's ever appropriate. And if they say that, they don't make it on that jury.
Right, and so that's something that has to be screened for in jury selection, and then ultimately at the end of that trial, if there's a guilty verdict, then they have to make that decision.
And a separate trial, basically. It's a
Correct. So there's
new testimony.
what we call the guilt phase, right? The guilt phase is whether the person committed the offense or offenses. And then there's a separate sentencing phase where this is the penalty phase, they call it, where the jury listens to, they consider everything that they heard as part of the guilt phase, but then the state now is allowed to put forward what they call aggravating factors, things that make it beyond a typical murder that may merit the death penalty. In this case, the court analyzed a couple of those different factors. One of them is whether, and we talked about this in Godot, whether the murder was especially cruel, heinous, or depraved, and other factors. That's not the only one, but that's an important one that is used frequently. If the jury finds that there are those aggravating factors present, then, of course, the defense can put on mitigating evidence or mitigation, and then the jury has to balance, does the mitigation outweigh the aggravation or vice versa, to the extent that either life imprisonment ought to be imposed or the death penalty.
It is so much to put on just an everyday person who gets dragged in for jury duty.
And it's part of what makes these trials very lengthy, because you're not just talking about who done it or did this person commit this offense. It's what punishment ought they to receive.
Yeah.
Okay, so let's dig into Miss Andriano for a second. So she was married to the victim, her husband. His name is Joe. They had 2 small children. Well, previous to this, Joe had been diagnosed with terminal cancer. They had gone to a barbecue. They had come home. It doesn't give the ages of their children. I'm not sure how old they were. They were living in an apartment complex. Joe, it didn't seem like, had very much time left to live. He was sort of on death's door, but we don't know exactly from the testimony, from the evidence that was presented at trial, how long he had to live.
Yeah, it's hard to say because there really isn't anything about that, only that it had been deemed terminal. And I think most of us imagine that generally that means it's pretty close because you must be pretty progressed in the disease.
That's right. And so they go to this barbecue on October 7th, 2000. They come back around midnight. Wendi puts her children to bed. At about 2:15, Andriano calls a neighbor. His name's Chris.
Wendi Andriano, right?
Yeah, her name's Wendi Andriano. Chris is the neighbor, co-worker who lives at the same apartment complex. She says, hey, come watch my kids. I need to take Joe, the husband, to the doctor. He meets her outside the apartment. She says, I have a problem. Don't ask any questions. My husband is on the floor dying, and I haven't called 911 yet, she says.
It's always a bad start. I got a problem.
Right. There's an issue, and I haven't called the police yet. And she says, he doesn't know that I haven't called 911, and Chris urges her to call 911. So clearly there's a problem with Joe. It's the late night hours. Chris enters the apartment. He finds Joe lying on the living room floor in a fetal position. He had vomited, appeared weak, has difficulty breathing, and then Wendi decides that she's going to call 911. Joe told Chris, so Joe was conscious at the time, that he needed help, and he's needed help for a long time. He asked why it's taking 45 minutes for 911 to get there. Joe apparently was not fully informed of what was going on, that Wendi hadn't yet called 911, and he's there just struggling on the floor.
I mean, you can imagine, it sounds like he said, hey, call 911, and that's what he thought she had done, and then she goes outside and talks to Chris and says, heads up, didn't call 911. So
that's right. So she says, hey, I'm going to go get the car. I'm going to go take him to the hospital. They're yelling, there's fighting. Paramedics eventually get there. Chris went outside to direct the paramedics where to go. Joe is still vomiting in the apartment.
Yeah, and at that point is odd. I mean, it's all odd. But she goes outside and tells them, "Go away, leave. I don't want you here." To the paramedics that are there. Obviously, Joe's in medical distress.
Right.
Her reasoning is that she says, look, he's dying of cancer. He's in there, and this isn't how he wants to go. He has a DNR, right? Do not resuscitate. And so we don't want your help, your medical help. He's just going to handle things here. Closes the door. They bang on the door to try to get in. No answer. They even call, I think. They find a way to call her the house. Yeah, she says, no, not going to happen. They leave.
But she comes around
Oh,
back.
was that during the first
That's
part
right.
of it?
That's right.
So she comes, instead of coming out the front door in his apartment complex, she goes out the back door, hops the wall, comes around and talks to them.
Yeah, it says here, Andriano went through the back door, climbed over the back patio wall, walked around the apartment building to the front door where Chris and paramedics were standing. Andriano had changed her shirt and her hair was wet. She told paramedics that Joe was dying of cancer, had a do not resuscitate order, and this was, quote, not the way he wanted to go. Paramedics and Chris left without going into the apartment. That astonishes me.
How?
That astonishes me that paramedics wouldn't have taken some measure or some step to try to see how Joe is doing. And it's super suspicious. I mean, for instance, if you call 911 and you hang up,
They're coming.
they're coming. I've had that circumstance. One of my kids years ago called 911. Cops show up at your door. You say, hey, what's going on? Like, oh, sorry.
6 years old.
Yeah. Whoops. But they want to know because they need to check to see if there's an emergency, because it's certainly not uncommon for people to dial and then something happens and, maybe the person won't let them use the phone or there's a domestic violence situation. Police have to figure it out. I'm shocked here that something more wasn't done to check on Joe.
Especially because you imagine that Chris is there. That Chris is the guy who just said he went in, saw him in the fetal position, vomited everywhere, in distress, saying he's in distress. I would imagine he conveyed that information to the paramedics.
But perhaps that's why paramedics were okay to leave, because he had seen the situation, right, and had sort of corroborated what Wendi was saying. I'm not saying it's a good idea. I'm just saying it's a possibility, right?
For them. Yeah.
I don't know. So Chris leaves, paramedics leave.
And this was 2:15, is that what you said, in the morning?
Around there. And then at 3:39 a.m., there's another twist. Wendi Andriano calls 911 again at 3:39. The same paramedics responded and saw her now wearing a bloody shirt, standing outside of the apartment talking to a police officer. They enter the apartment this time. They find Joe on the floor in a pool of blood. He had a deep stab wound to the left side of his neck and lacerations on his head that exposed some brain matter. Police detective observed around 3:52, so a few minutes later. The blood surrounding Joe's head was already starting to dry. A broken bar stool covered in blood was found near Joe's body, as were pieces of a lamp, a kitchen knife with blood on the sharp edge, a bloody pillow, and a belt.
Okay. So, ugly. And what is her explanation? Isn't this obvious, right? Don't we hear this and say, what is she going to claim, that some guy came in here and did this to Joe? No. She claims, right, this is her defense, and it starts from the day of, is that Joe is terminally ill. They had some type of an assisted suicide agreement that she was going to help him commit suicide because he just couldn't handle what he was going through with cancer. It was failing as far as this attempt, and I believe it was through poison that they were saying it was
so
initially.
They had a storage unit that was searched. Inside the storage unit, there's a cardboard shipping box with 500 grams of sodium azide. Sodium azide is a poison. In fact, I think it's used in airbag modules. Okay. You're not supposed to consume it.
Not good for you.
Okay, not good for you. 2 Tupperware containers containing sodium azide, 9 Q-tips, a plastic knife, a fork, latex glove, whatever.
This is in the storage.
This is in the storage unit. So this is obviously discovered later. Okay. But there's this poison. Some of that poison is unaccounted for. They weigh it, and a certain portion is missing.
They find it in soups that are in the kitchen, and they find it also in some other things in the kitchen, I believe.
Correct. Trace amounts of sodium azide were also discovered in the contents of a pot and 2 soup bowls in the kitchen. In all, 20.8 grams of sodium azide could not be accounted for. So some of it had been used. Now, well, I'm not going to speculate.
Right.
I'll get into the medical examiner.
So she's claiming, when police come, look, we tried this assisted suicide. It wasn't working. He became upset. At some point, she admits to him during this process that she's been having an affair.
Mm-hmm.
He becomes enraged. She then claims that she's already been the victim of domestic violence at his hands in the past, that she defended herself with the stool, hit him over the head with the stool, and that he then Oh, that she had a knife. He then grabbed the knife and stabbed himself and slit his own throat.
And we'll get into her testimony, regarding that. And she did testify. A number of times we've discussed cases about defendants who choose to testify, don't testify. Wendi, in this case, did testify, and we'll get into her testimony in just a minute.
Yeah, we've talked about that. Also, self-defense cases.
Sure. There's an important reason to testify if you're going to be claiming self-defense, and we've covered that before, which is you got to get that story out. Usually you're the only person who can offer that type of explanation.
Which was certainly the case here.
Right. Yeah, because kids are asleep, neighbor's gone, there's no paramedics, there's no witnesses to this. It's Wendi and Joe who are in that apartment, going through this experience.
And people don't think about that. In trial, you think you can just tell the story, right? Like, well, can't my lawyer just tell the story?
Okay.
It has to be presented as evidence through testimony or other physical evidence. And so in order to tell that story, you need the witness, which is Wendi in this case.
Yeah, and we've covered other topics like circumstantial evidence. And, even if there is, say, biological material, forensics, ballistics, those things don't speak for themselves. Yes, they can offer facts. They can confirm things. They can help. They can be instructive, but they don't tell the story, at least not the whole story. And so for Wendi, who is in this circumstance, she's got to explain what happened. Now, we'll get into whether a jury believed her account or not. The medical examiner determined that Joe sustained brain hemorrhaging caused by no fewer than 23 blows to the back of his head, 8 to 10 of which independently could have rendered him unconscious. Defensive wounds on Joe's hands and wrists indicated, however, that he was conscious for at least part of the attack, so he's trying to fight back. Joe also sustained a 3 3/4 inch by 2 inch wide stab wound to the left side of his neck. This is what you spoke about a minute ago, about this stab wound to his neck that extended to his spine and severed his carotid artery. Self-inflicted? That's tough.
They say it was really deep. Obviously to the spine. I mean,
well, and it severed his carotid artery, so he's going to bleed out.
That's going to kill you real quick.
The medical examiner opined that the blows to the head were sustained before the stab wound to the neck and that Joe was still alive, though likely unconscious, when he was stabbed. Which is an important fact, because if you're claiming that he stabbed himself, those blows to the head and the other, facts may undercut that. They do, according to the medical examiner. Trace amounts of sodium azide were found in Joe's blood and gastric contents. Cause of death attributed to blunt force trauma and the stab wound.
And I'd be interested, we've talked about before as well, battles of experts.
You're
right, where you have this expert or this medical examiner saying that they can pinpoint injuries and when they occurred. And I feel like that's a big bone of contention a lot of times between experts, right? To say, there's just no way you can say that happened for sure.
Or the timing of things, which came first and
not who did it. Sure.
Correct.
Sometimes they say they can tell that too, but just based on angles and things like that. But just, that particular fact here, I just wonder if there was kind of a competing expert to say, I don't know if you can say for sure that didn't happen in that order.
Well, and it's interesting because part of this include opinion offered by a police detective, which police certainly can be called as experts in given areas. Yeah, it has to be an area that they have specific training and experience on enough to say, I'm educated, I'm trained, I'm experienced enough to offer an opinion. This detective opined that Joe was lying down while he was being struck and did not get up during the attack. This was based on blood spatter evidence.
That's really interesting. I didn't catch that.
Yeah.
Because normally that would not be allowed to be testified to by a detective.
Right. Anytime it says the detective opined, he's offering an opinion.
Yeah.
Typically, police, in most of their testimony, will be offering observation.
Fact.
Right?
Yeah.
Fact. I got there at this time. I did this. I saw that.
This person
whatever.
said this. Yeah.
Exactly. Whereas here, this detective apparently had some level of experience or expertise enough for the court to allow him to say, I'm offering this opinion as to blood spatter, evidence and whether he was lying down or not. He further opined, based on the absence of arterial spurting on the belt and knife, that both items were placed besides Joe's body after he died. Blood spatter on the bar stool, on the other hand, suggested that the stool was present when the arterial spurting began. And I apologize for the graphic nature of them. This is a pretty ugly scene, but I mean, interesting that this officer now, or this detective, is saying, I can say, that because there's no spurting on this and that they weren't present, but there was on the bar stool, meaning he was bleeding out before he was stabbed or before he passed away.
My defense attorney alarm bells are going off all over the place here. I mean, this just wouldn't fly, I don't think. I mean, if we were
in court, fly.
I know, but this was 2004 when this happened, the first trial? I don't know what's changed. I feel like blood spatter expert testimony is very scientific and gets governed under really tighter rules of admission.
Well, it's going to be governed under Arizona's Daubert standard.
It wouldn't have been back then.
I
I
agree.
Different, yeah,
that's true, and that was clarified. The rules of evidence were updated in Arizona. It's a good question. Would that be admissible today? I don't know. I also think it depends on the judge. I mean, sometimes one trial judge may interpret something differently than another.
Yeah, and we've talked about that with 404B especially,
sure.
where prosecutors want to use people's other acts that weren't part of that case to establish something in a case. And again, we're going to see that rear its head in this case.
Yeah. So a few more facts that were presented at trial. After being taken into custody, Andriano called one of her coworkers and asked her to hide certain items that were in her business office.
Not a good look.
Not helpful. Andriano's adoptive father told a police detective on the day of the murder, quote, I remember Andriano telling me that she stabbed Joe. And that fact of stabbing Joe is important because she later testified that Joe either stabbed himself or, was stabbed in sort of this battle that they were having.
And it's not totally clear, but my understanding is that's what she told police at the time, too, on the scene.
So she was indicted on one count of first-degree murder. So first-degree murder in this situation would have been a premeditated murder, okay? The state did file notice to seek the death penalty, and that's something that they have to do. They have to put the accused on notice. We are seeking the death penalty, and there's a certain time frame within the rules within which they have to file that notice. If it goes past that date, they can't seek that notice any further. It helps procedurally to prepare the case. Is it going to be a capital case or is it not? And the defendant, the accused, needs to have that understanding. I've been involved in cases where clients charged with murder, and we're in that time period where the state is deciding whether they're going to seek the death penalty. And
a lot goes into that.
A lot goes into that decision making. At least in Maricopa County, it's not a decision that's made by an individual. It's a committee that gets together, and they decide whether they're going to seek the death penalty. And the burden is kind of on the defense to proffer mitigation and say, hey, this is not a capital case. That's sort of the first layer of protecting your client against the death penalty by advocating at that level and trying to get the state not to seek the death penalty.
And there's some risk, for the prosecutors because, there's a whole host of requirements and, really an elevated proof that they have to have for the case and beyond, even if they get the conviction, the next level to getting the...
Of course, and you're also... You have to think about the amount of time and resources. And as a former prosecutor, you also have to think about what's the impact of this on the victims, right? Does the family want to go through a capital case? We've seen this right now in this Koberger situation up in Idaho. We'll deviate a little bit here on that. Capital case, multiple homicide in Idaho. He is set up to go to trial in a capital case where they're seeking the death penalty. And what happens? Last minute, there's a plea deal. He doesn't end up going to trial. He takes a plea. He's spared the death penalty. And now that shortcuts. There's really very few remedies for appeal or post-conviction relief following a plea. And so all of those factors have to be taken into account when the county attorney's office or district attorney, whoever is the prosecutor, decides death penalty, no death penalty. Here, they seek the death penalty. The aggravating factors, remember, you have to have a couple of these factors in place in order to get the death penalty. They said that she committed the offense in expectation of receipt of pecuniary gain, meaning there was some money expectation that she was hoping to receive as a result of Joe's death. And then the other one, because the offense was supposedly committed in an especially heinous and brutal manner. She testified. You touched on this. At trial, Andriano testified that after a failed assisted suicide attempt by poison, she and Joe got into a fight during which she hit Joe with a bar stool in self-defense. She claimed that he ultimately slit his own throat. That was her testimony. Anything we left out on those facts?
Probably, but that's, I think, the basics. I mean, it's a bizarre set of facts and a bizarre story
Now,
to say how it all happened.
Right, and Joe was terminally ill.
That's one of the things that really gets me about this case, right? Is if you're going to say that she murdered him, I think a pretty good argument is to be, why? Why would I murder this person even if I wanted them to die? He's dying. I just had to wait, right? It's who murders a terminally ill person?
Well, and I guess it raises the question of, is that murder or is it assisted suicide? Or I don't know. I mean, clearly, when you take someone's life, it's murder, whether they're terminally ill or not, right? They went down the road of potentially assisted suicide. Now, I just ask myself the question, like, that sodium azide, did Joe really know he was taking those things?
Yeah, that's how you're going to kill yourself? You're going to slowly poison
yourself? This raises some serious questions in my mind, right? And the same thing about the terminal illness. Why do it? Why not wait 6 months? I don't know.
But her story, I mean, about what happened, just there's a lot about it that's tough to swallow, right? That she's putting down, and you're looking at it and saying, gosh, that sounds like a pretty odd situation of how this guy died, and how you're saying this was a self-defense situation.
Agreed. So let's dig into the trial a little bit. One of the things that we've talked about a few times is, what can the jury hear that is beyond the facts of the murder, right? We all know that in that apartment, the when and how and what happened, that of course is going to be presented at trial.
Yeah, so you're going to have an officer come in, testify, just like you said, to what they observed. You're going to have an expert come in and talk about the substances that they found in the storage unit and then in the foods that were there. And they also testified that it was found in his body.
That's right.
In the autopsy, right? You're going to have somebody testify to the scene and what they saw as far as the stool being shattered and the horrific injuries that he had. And then the question, like you said, is, what about other things? And this is other, things that aren't about the act or the situation itself. And the general rule is people's other acts don't come in.
They don't come in unless the state can squeeze them in somehow to dirty up the person.
And remember, who do we have as our prosecutor here? Juan Martinez.
Was that right?
Yes.
Oh,
yes.
I didn't pick up on that.
He's our old favorite. No, we've talked about Juan multiple times. He did a lot of high-profile murder cases during this time in Maricopa County.
No longer a lawyer in Arizona.
Yeah.
He gave up his bar license. We talked about that.
We talked about that in pretty good detail. But this was another one of those cases that has some similar accusations of his behavior during this, where he would try to inflame the jury with some of these things that we're going to talk about that were outside of the actual act itself.
Yeah, so these other acts, we call it 404B evidence, these other acts that the prosecutor was able to get out, two key facts. One, the fact that Wendi tried to acquire life insurance on Joe's behalf.
After his diagnosis.
Unsuccessfully, but she tried.
And she did some dirty stuff to try to do it.
I'll read this from the opinion. She asked two men to pose as Joe for a life insurance physical exam, one of whom she offered to pay as much as $50,000. Both refused.
In those applications said that Joe did not have cancer.
Yeah, which is a crime in and of itself. I mean, you're committing forgery, fraud schemes. We talked about that in that Prescott case that we covered a few weeks ago. But so the jury hears this idea that she's trying to, reach after or obtain life insurance for Joe. And especially by doing it in a fraudulent way, that does not make you look good in front of the jury.
And that's interesting, right? The other case that we talked about, they actually charged those offenses. Mm-hmm. And that's what we said. We said, well, that's kind of smart, because then that comes out in the trial case, right? Without you having to say those are other acts, because they're specific to that charge. and then you just got to keep the case together.
Right.
But in this case, they didn't charge anything else, and so they had to say this evidence is admissible because of X, Y, and Z, right?
Yeah, and it's for those same reasons that we've talked about under 404B, which is proof of plan, knowledge, motive, identity. Here it goes, I think, to a plan or a motive to murder Joe because she's hoping to cash in on whatever policy is obtained.
And that's kind of interesting because it goes beyond kind of that normal list that we talk about of things that it
Sure.
can show because they did charge it as premeditated. So that becomes a direct element of this case, is that it's showing some premeditation.
I want to touch on this. The court does give us a little bit of explanation of Joe's condition. They say after 3 surgeries to remove a recurring tumor in his salivary gland and as many misdiagnoses, Joe was diagnosed with metastatic adenoid cystic carcinoma in 1998, 2 years before his murder. By that time, the cancer had spread to his lungs and his condition was deemed terminal. So he's not going to survive this cancer. We're not given a prognosis for, how long he's going to live. But clearly, he's not going to survive for very long. And during that time, of course, she tries to get, in August and September, a month or two before these murders is when she tries to get these insurance policies. So the jury gets to hear about that.
Which is really interesting because she didn't even successfully do that because, part of it, you always hear about these cases where that evidence comes in all the time because they say, yes, they got a life insurance policy on them and that's the motive. But they didn't get it, and they did charge as one of the reasons that for it to be a death penalty case is for pecuniary gain or for money, right? But she knew she wasn't getting the life insurance on that.
Yeah, by the time Joe's death had occurred, she would have known that there's no insurance policy in place.
Right. So I thought that was interesting. But still,
yeah. So the other aspect, or the other 404 other act fact that came in was, of course, extramarital affair.
Oh yeah, and that's a Juan Martinez special. That's what
He
loves to talk about that stuff. Yeah.
Yeah.
Well, to be fair, all prosecutors love to get a hold of that because the jury hates them.
Any dirt that anybody can raise against the defendant, they're going to do it. If they can do it in a way that can make it relevant for the case. And here, that extramarital affair became, again, part of the motive in getting rid of Joe
so
because
pursue her other.
Yeah. So she, in the summer of 2000, she had an extramarital affair with a guy named Rick, a resident of the apartment complex. She also frequented bars on a weekly basis with coworkers and friends. She was seen dancing, flirting, groping, kissing on men. On September 27th, it says, the evening after Joe's 4th chemotherapy treatment, she went to a dance club, met somebody, brought him back home, apparently had, some relations with him, and had told the guy that her husband had already died of cancer. And this is just a couple of weeks before the murder.
Yeah. And there was also some testimony from a hairdresser where she had gone in on 2 different occasions, months before this, saying she wished Joe was dead so that she could move on with her life.
Right.
What else? There was another statement that she made to this hairdresser also that came in at trial, basically saying that she wished that Joe was dead.
Yeah, and then you mentioned Juan Martinez. The court talks about his style, which was to, quote, take every opportunity to infuse the trial with marginally relevant information about Andriano's partying and man-chasing. At least that was Andriano's characterization of Mr. Martinez throughout the trial, which I'm sure there's truth to that. I mean, this trial certainly was riddled with sort of extra stuff to make it interesting and to make the jury not like Wendi.
Yeah.
Right?
Yeah.
Okay, so the court allows that in. On appeal, the Supreme Court says, yeah, that's okay.
And we've talked about this again. I know we keep harping on this 404B thing, which is the rule of evidence that it is. It's Rule 404B. And we've said this before, and I think it applies here maybe, is that you can win and lose a trial. It can make the difference on whether that stuff comes in, which is interesting because the whole idea is it's not supposed to, necessarily make the difference on guilt or innocence. It's just supposed to be Well, I guess it is. It's just not supposed to say you're guilty because you did these other things. You're only supposed to use it for a limited purpose of, look, I'm not showing you this, that she did these things and sought the life insurance or went out and did these things in order to show you that she because she did this, she also killed him. They're saying this other evidence helps you see that she had a motive to do it, and this evidence shows that she had some previous premeditation to it.
It explains the why behind it. Again, 404B can be very powerful, and here, it gives the prosecutor some ammo to really solidify this. Now, the question I suppose is, take out the 404B evidence, does Andriano still get convicted? I don't know the answer to that. That's a tough question.
I don't think we've said that yet. Dang it. No, that's all right. I think that's where we're at right now, is that at the end of this trial, with all that was presented, she was ultimately convicted of that one count of first-degree murder. Then they went on to the guilt phase.
Right. But before we get there, before we get to the penalty phase or the death penalty side of it, there was one other element that was argued on her appeal, which was, what level of homicide should this be? Okay, she's charged with first-degree murder. There are different levels of murder in Arizona: first-degree, second-degree, manslaughter, negligent homicide. Many times in a trial, if the state charges, let's say, first-degree murder, depending on the evidence and depending on what your defense theory is, you may be going after a lesser form of murder. Like, you can say, look, our defense is not that the person wasn't killed, but they weren't killed in a premeditated way. It was an accident. It was manslaughter. And even though the person may be found guilty, they're found guilty of a lesser crime. They're not subject to the death penalty. They're not subject to life in prison. And so here the court analyzes, because the defense attorney in trial didn't ask for the jury to be instructed on these lesser included offenses.
That's the key, right? Is that in order for there to be lesser included offenses, is what we call it in Arizona, which is those lower levels, then a jury's not going to know about that unless they get instructions on it, right? To say, hey, look, you might find that it doesn't reach the level of first-degree murder. If that's the case, you now consider it under these set of law and facts, and you put those two together and decide whether that one matches. If that's not included, then if they're not guilty of that, then you can look at this lower one. Yeah, defense didn't ask for those lesser included offenses.
And I'm kind of surprised by that, because I do think there are potentially other theories to the murder rather than simply first-degree murder. So state is saying this is premeditated intentional killing. But you also have a situation where there's this heated argument and somebody dies. Could that be second-degree murder, where there's a sudden fight and you knowingly or intentionally kill that person, now without premeditation? That's second-degree murder. Or could you engage in that same sudden fight in the heat of passion, and now that becomes manslaughter? Okay. The court analyzes that and really says there's no evidence to support any of those theories.
And I thought, too, the interesting thing that the court said was part of the problem isn't necessarily that the attorney didn't object. I think that matters because of the standard that they were looking at. But also they said the problem is you made a defense of self-defense. And because you said it's self-defense, you're saying that you're not guilty. It's a, if you believe me, it's a not guilty, regardless of all those other things. If you don't believe me, then it's first-degree murder, right? And they said your own defense is really what precluded the opportunity for you to have lesser includeds.
So that raises the question of, how do you choose that strategy going up into a trial? Is it better to sort of spread your net wider and say, hey, I'm going after second degree and manslaughter if I can get it, and I'm going to, I'm going to say, this or that to try to get to that point? Or do you say, I'm all in, right? I'm pushing all my chips in the middle. I'm going to say this is not first degree murder. It is self-defense. My actions are justified. And that's what defense went with. And the court basically says that's what the evidence, that was presented, that's what it showed. It was either self-defense or it wasn't. Self-defense is harder to come across, though, when you've got the insurance policy and the extramarital affairs. now that becomes motive for the state. And I can see why the state would want to make those things relevant.
Yeah, and it's hard, right? I mean, because a lot of times some of this stuff gets dictated, in concert with your client, with the defendant, saying, look, here's different ways we can defend this case.
Mm-hmm.
Often it's hard for somebody who's made this claim to say, yeah, cool, let's put it in front of a jury that maybe it happened another way, that it wasn't self-defense, when really that's been their thing the whole time. There's also strategies out there where you put forward alternative theories.
Mm-hmm.
And that's generally not a favored way to do it by defense attorneys, at least that I've spoken to, because an alternative theory is to say, hey, jury, it was self-defense. But if you don't believe me on self-defense,
right, then it was a lesser, right,
right, and that's just not a very compelling argument when you're really trying to argue a particular case to
right. And the Supreme Court here, they give a really nice summary of what the law is. I'll just read it. Where the sole defense is self-defense, so that the evidence requires either conviction or acquittal, any instruction on other grade homicide would be impermissible. So it's an all or nothing thing. You go for it or you don't go for it. Here, the defense chose to go for it. I can't armchair quarterback that. I wasn't there. I didn't hear all of the evidence. I don't know exactly what was presented, so it's hard for me to say that was right or it was wrong. I do, though, wonder, would it have been successful if they had tried to shoot for something other than, a self-defense all by itself?
Because again, jury doesn't know that's an option if it's not put out to them.
That's
right. And sometimes they do what they call split the baby.
Yeah.
Right, where it's it comes from King Solomon in the Bible, but basically saying, I don't know, I don't believe, I don't necessarily want to go with first-degree murder, but I also don't want to say she's innocent or not guilty and just put her back out on the street. You're giving them another option to go in between somewhere.
But if your client is charged with first-degree murder, facing the death penalty, and you come away with either a second-degree murder conviction or manslaughter conviction, that is a win.
Most of the time.
You win.
Yeah.
Because now your client has a definitive sentence and will come home at some point, right? A life sentence or a death sentence, they are not getting out of prison.
Right.
So moving on to that penalty phase that you mentioned, the jury found her guilty. Prosecution had alleged two aggravating factors. One is this pecuniary gain, which they did not find. The jury here did not find that this was done in pecuniary gain, probably for the reasons that you mentioned a little bit ago, that she actually didn't have a policy. Right?
Yeah. Where was the gain?
And then the other one was whether this offense was especially cruel, heinous, or depraved. And I think from there, just to summarize it quickly, this was a pretty brutal homicide. He had suffered, extensively. If you look at the first 911 call into the second, and the fight, and the bar stool, and the hits to the head, and the stab to the neck, I mean, this isn't a quick death. It's a long, torturous death, right?
A lot of suffering. And they've talked about some death penalty cases where it's very quick, right? Where they say, hey, it doesn't have to be hours long or minutes long. In fact, I think that was talked about in the Baseline Killer case, where they talked about the anguish that these women would go through just in the moments before their death, knowing that that's going to happen.
Yeah, in the drive to the location or whatever it was, that thought of sort of impending doom, I think is what the court calls it.
Yeah, the tough thought is enough. I mean, think about that. This guy was on the ground in the fetal position,
vomited 2.5
hours or more before ultimately they showed up, and he was just brutally beaten. And based on, the ME and what they talked about, that he was conscious for a great deal of this, and just the level of it, talking about that brain matter was visible. I mean, that is a brutal.
So jury votes for death. And I want to, I guess, spend our last few minutes talking about this. Wendi Andriano is, in Arizona, the only woman who's currently on death row. Am I right? Am I wrong about that?
You're wrong about that.
Oh.
There are 3 women.
Go ahead.
Unless one of them's been executed recently, which I don't think we've had any execution. We've had one recently. So that she's one of 3. I wish I brought the numbers in with me. I can't remember. I believe there's a couple of hundred men on one, just over 100.
I think it's just over 100
on death row in Arizona, and so it's very rare. It's very unusual, but she's one of 3. Nationwide, the numbers, gosh, I should have brought that in with me, but we're at about, I believe there's about 40 to 50
Total
women
Yeah.
on death row in the whole country, and there are about 21 to 2,300 men on death row. So it is rare to see a woman on death row, which is interesting because last week we talked about Winnie Ruth Judd, who was also sentenced to death and was on death row for a while until she was no longer until she got to go.
Until the sheriff said that she didn't longer qualify for that somehow. We still haven't figured that one out.
Yeah.
So Miss Andriano, she's on death row. She is, I don't know what the status of any further appeals. As you may have gathered, as you know, death penalty appeals can last for a long time. Often death penalty sentences aren't carried out until 15, 20, 30 years later sometimes, which again, going back to that Kohlberger case in Idaho, it's one of the reasons why a prosecutor may offer a plea to sort of wrap things up. Yeah, he doesn't get the death penalty, but he's not going anywhere.
And it gives finality for the family, to the case, instead of just that this is going to dominate their life for the next 20, 30 years.
Yeah. I mean, it's all of these cases are tragic circumstances, human beings making bad choices, and then, ending up locked up behind bars and facing the death penalty. Tough situation. And of course, this case, when it happened, grabbed some headlines. And of course, we talked about Mr. Martinez being in the limelight quite a bit.
Yep.
This is one of his cases. Any parting thoughts?
No, I mean, this is just, every time we do one of these, I'm thinking, especially the last couple where, we had Winnie Ruth and this one, it's just, it strikes me as what must be going through these people's minds and hearts when this happens. Right?
Victim or the defendant?
The defendant.
Yeah.
I mean, obviously the victim, awful and tragic, but as far as how do you get to that point in your life that you think that this is the solution or that this is an appropriate, step to take?
Yeah, and I think some acts are more acts of desperation, sometimes. Others, I think of the baseline killer, are more acts of sort of depravity, right?
Psychopath.
Yeah, somebody who's just, who's in a different place mentally, right, than most people. This one is a tough one for me to understand, going back to the idea of, he's already dying. I can't figure that one out.
Yeah.
Obviously, there's circumstances there that you and I don't know, and I think we have to understand that. Not that it certainly does not justify Wendy's killing of Joe. I mean, I think it makes it all the more tragic that you've got this poor man who's, suffering from cancer, and wife then goes and does this.
Yeah, it's awful. So, but always good to talk to you about it, Dave. I love your perspective. I love listening to what kind of the process looks like, and what happened in this case, kind of in the details. So I appreciate it.
Yeah, thank you. Appreciate you.